It is Wednesday. It's April 16th. We are going to be in court today for the Karen Read retrial. Technically, we are at the beginning of trial 2 for the Karen Read case. Karen Read went through trial number 1. At the end of that trial, the jury was unable to reach a verdict. The court declared a mistrial, and then all the wheels continued to come off. Do we expect anything else in this case? 100% no. Is anyone shocked that in this case, where so many things are already not the way that they should ever be, that the wheels continued to come off? Not shocked at all. A jury was selected yesterday, April 15th. They started April 1st. They selected 18 jurors. We had been hearing reports that they would do just 16. They decided to do 18. I think that's the right amount. Because what we're going to find is even after a weekend, after a holiday weekend, you're going to lose a couple people on the jury. You're going to lose alternates. Last trial, I think they lost 2 or 3 before they even started opening statements. So do I think they'll even start this case with 18? Maybe not, but they have 18. So the question is, why aren't we doing opening statements today? We're not doing opening statements today because today is Wednesday before Easter weekend. I imagine the court had intended to be off on Friday. I imagine the court had intended to be off on Monday because it is Boston Marathon Monday. It is Eastern Monday. That is a 4-day weekend. I imagine the court's already planned on that being a 4-day weekend. And from what I'm seeing and reporting, they asked the lawyers if they wanted to start opening statements Thursday or Tuesday. And they all said Tuesday. Of course they did. You don't want to do opening statements, one witness, and then have like a 4-day break. That's the worst ever. Also, they are a little bit ahead of schedule. The court had intended starting around the 27th, 28th, and had given that much time for jury selection. So in the court's mind, they are ahead of schedule. So gave the lawyers a little bit more time. I think that's good for everyone involved. And I think it's good for the lawyers. They're not in a rush. It makes sense. You don't want to piss off your jury immediately first. Like, do not piss off your jury right out of the gate. So the jurors get to get their things in order. But today they're doing hearings. Why? There are still things that are unresolved. The Commonwealth wants to use Karen Read's interviews against her. They are statements of a party opponent. Those are going to come in. The argument will be how complete those statements need to be because the defense cannot take an interview from Karen Read on TV and say, we're admitting this. Can't do it. The prosecution can. Karen Read's well aware of that. We're well aware of that. After court yesterday, they asked her and she basically said, come at me, bro.
How do you feel about Hank Brennan planning to use your interviews in his opening statement? Come at me.
I mean, she did say, come at me. The bro was missing, but she said, come at me. It's going to be interesting to see if they try to do that with transcript or video. I imagine they'll try to use the videos. We're going to see a very different trial 2 than we did see trial 1. So today we will hear about what exhibits they might be using during opening statements. We will hear about what's going on with the experts. I'm sure Brennan will complain about the ARCCA experts again. We will be hearing about Karen Read's statements, I'm sure. So we're going to deal with those last motions before trial starts. So these are not technically pretrial motions. Some of them carried over from pretrial because we are at the motion stage.
At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I ask this court to do.
Your Honor, what appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony, or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can.
The court wrapped up a lot of loose ends in the hearings today that we all watched together, from whether or not Aidan Kearney, aka Turtle Boy, will be excluded from court during all of the testimony, just some or somewhere in between, to what exhibits will be used during opening statements. And we saw the Commonwealth have an absolute hissy fit over ARCCA, because of course they did. Today was a lot. Let's talk about ARCCA real quick with the Commonwealth. Attorney Brennan was just yelling in court today, saying that they do not have discovery sufficient on the ARCCA witnesses, that the defense is engaging in trial by ambush, and that new opinions by ARCCA at this point is unfair. And he reiterated, with actually a hand slap on the podium, I am not saying that ARCCA can't testify. I am asking the court to order them to turn over discovery and to constrain their testimony to the opinions that they've turned over. And the defense said, Your Honor, we can't do our work if they don't do theirs. It was his 50th birthday.
Hello, it was his 50th birthday. Whatever. If she doesn't do the assignment, I can't do mine.
They turned over their Dr. Welcher to us late. We didn't even get that shit till February. So how do we have our experts look at what their experts said if we don't have what their experts said? So the defense said the only thing new that ARCCA's been given is the Commonwealth expert information. And they gave ARCCA the report from Dr. Welcher, which was the 140 PowerPoints of whatever on accident reconstruction, and the materials that Dr. Welcher looked at to review their experts. Having experts check other experts is a regular part of court. And the defense said, we didn't even get that shit till February. And then we had to do a request through the federal government to be allowed to hire ARCCA to look at this for us. And they didn't get that back to us till March 26th. So we're doing the best that we can. And the Commonwealth is aware of this. But in Brennan's argument, he said, Your Honor, we can't have new opinions coming in from ARCCA after we've made our opening, after we've told the jury our theory of the case, after we've presented our science. And as I was streaming, my pondering on that was, your case should be solid no matter what holes ARCCA tries to poke in it. Your science should be solid. Your case should be built on your evidence, not a rebuttal to the defense. And where the Commonwealth was constantly on the back foot in trial number 1 was that they were trying to prove their case and simultaneously disprove anything the defense might say. And it got way too convoluted and their theory of the case got lost. What, if any, theory of the case was presented? And if the Commonwealth is going to try their case by disproving the defense, they are going to end up in the same position where their case is not clear. The Commonwealth needs to try their case based on their evidence and their theory of the case. The defense needs to try their case based on the Commonwealth didn't prove any of this to you. If they keep it simple, I think it will be much easier for a jury to understand, because at the end of the day, there will be medical testimony about whether or not John O'Keefe was hit by a car. And if that becomes the focus of this case, I think it will be a lot less confusing for everyone involved. But when there are a million different rabbit holes to run down, that simple point gets lost. Was John O'Keefe hit by a car? Was Karen Read driving that car? That is the core of this case, and it got very lost in different aspects of the first trial. So the court didn't rule on that yet, so hopefully we'll see that ruling by Monday. There was some discovery conversation. A lot of it got worked out. There was conversation about what will be presented in opening statements, which we see are going to be done by Attorney Brennan and Attorney Jackson. The Commonwealth said they're going to be using what looks like a 15-second clip of one of the interviews Karen Read gave. The Commonwealth is going to use Karen Read's media interviews against her in this trial. And the defense is going to use the internal affairs investigations against the state troopers and former state trooper Proctor against them. And so all of that was hashed out today with, yes, the Commonwealth can use Karen Read's media statements. That's appropriate statements of a party opponent. And yes, the defense can use the findings from the internal affairs investigations as to former Trooper Proctor, Trooper Buchanan, and Trooper Tully. Those are going to come in. And then when we got to the very end of the court day, we had a hearing with regard to whether or not Aidan Kearney will be excluded from being in the media pool during this case because he's on the Commonwealth's witness list. And his attorney came into court and said, if you call him to testify, he has 16 pending indictments for witness intimidation, and we disagree with the Commonwealth's reading of that statute. That disagreement aside, if he's called to testify in this case, he would plead the fifth. And the Commonwealth conceded, if he pleads the fifth, then we do not have a good faith basis that we can call him as a witness. And then they just hashed that out. There was a colloquy between the judge, Attorney Bradel, and Aidan Kearney, and they discussed, the court made a finding on the record that he has reason to plead the fifth, that he would plead the fifth if called to testify. And when the court made that record, she then ordered that he would not be subject to the sequestration or exclusionary order, that he would be allowed to be in the courtroom except for the same conditions that we saw in the first trial, which were the juvenile witnesses, which there's a full media blackout on, and for the witnesses who are part of any of the witness intimidation indictments. There are stay away orders in those, and he cannot be in the courtroom for those witnesses. So same order as the first trial with the added step of the Commonwealth adding him to the witness list, and he will be allowed to be present in court as there is media access. It's my understanding that all media access to the court is on a lottery system that's pulled weekly. So week by week, I'm sure the gallery will be changing. And that is where we're at before opening statements start on Tuesday. Will more happen? Probably. And we'll talk about it either on Tuesday before opening statements start or in the Emily Show podcast on Monday. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.